Hey y'all, Bonnie Roden here, your favorite family law attorney, serving East Central Florida, Brevard County. I'm here to talk to you today about mediation. If your Florida custody case is headed to mediation, there is a good chance that you are walking in with an expectation that is about to be disappointed. I would rather disappoint you now on video for free than have you find out in a mediation session. So let me tell you where the law starts now. Since 2023, Florida law presumes that equal time sharing, 50-50, is in your child's best interest. That's in Florida Statute 61.13. Don't get me started on whether I agree with it, because I don't, but this is the law that I work under. So 50-50 is where we start. That is not what a judge might do. That is where the judge begins. Every case, before a hearing, before a word is said about your family, the judge starts at a presumption of equal time sharing for each parent. You can overcome that presumption, but in practical terms, the bar is really high, and it's high for a reason that has zero to do with fairness and everything to do with proof. To move a judge off 50-50, you have to show the court something, not tell, show. Records, dates, messages, documents, witnesses, stories, and the witnesses who are not you. So you can be a witness and give testimony, but other people that can testify to things that will support what you're showing the court. Almost nobody documents their life well enough to do that, because normal people do not live like a litigant. This is the gap that I would love to close. So I'm going to take a few minutes and try to explain this, and it may help you if you choose to learn it and practice it. All right, so what actually moves the court? There are three composite examples that I have. These are patterns that I see constantly. It's not any particular case, but I see these repeating themes. One parent tells me the other parent is chronically late for exchanges. Standing alone, that's not really anything. The same parent with 14 months of time-stamped messages showing arrival times, plus a pattern the other parent acknowledged in writing, now has something a judge can actually act on. All right, here's the second one. Parent tells me the child comes home exhausted and hungry every time. Standing alone, that's not really anything. But the same parent comes in with a contemporaneous log, a pediatrician's note, reflecting that the concern was raised at the time of the doctor's appointment, and maybe school attendance records showing Mondays that the other parent had the child with tardies, or even reports from the teacher where they come in on Mondays or on that parent's days saying that the child is sleepy or sleeping in class or is not as effective in class. That one now has a case. Here's a third example. A parent tells me the other parent skips the child's medication. Standing alone, we can't really do anything with that. But the same parent with the school's medication administration log, or a treating provider's note documenting missed doses, or who has logged and documented picking up the prescription, how many pills are there, how many went to the other parent, and how many came back. That parent now has something from outside of general complaints. Notice what changed in all three. Not the facts. Facts didn't change. The parent's honesty did not change. What changed is whether anything existed outside the parent's own comments. That's the whole difference between a claim and a case. All right, so text messages. Text messages are not enough. They're good, but they're not enough. Here's what can fill in the gap. Almost everyone asks me the same question. How do I document something someone said? And then they say, well, I have texts. Texts are good. They're good. Keep every one of them. Make sure that you secure them so that you don't lose them. But the reality is that texts only capture the part of your life that happened in writing. And in family law, a lot of what happens that matters, it happens out loud. It happens in a driveway at an exchange. It happens on the phone, at a birthday party, maybe in front of the child or other people. None of that is in your text messages. And when you go looking for it 2 years later, it's gone. And all that's left is a comment that the mom or the dad acted a fool at so-and-so's birthday party. The details are gone. What fills that gap is a narrative. A narrative is a short, factual account or statement of an event written the same day that it happened. I call it a logbook. Other people call it other things. But a short little story about what's going on and what happened makes all the difference when you someday might want to go to a court for a solution. Here's what goes into a narrative: the date, the time, as precisely as you can, where you were, who else was present, by name, what was said, quotation marks if you can use them, and what you personally saw and heard and experienced with your five senses. So here's the part that a lot of people get wrong, and it's the difference between a narrative that helps and a narrative that doesn't. Write observations, not conclusions. Do not write, he or she was drunk. That is a conclusion. It is the kind of thing that draws an objection in court and then is excluded. And it also makes you look like an advocate instead of a witness. Write what you actually perceived. Speech was slurred, unsteady coming up the walkway, smelled like alcohol when leaning into the car, asked the same question 3 times in about 2 minutes. Don't write, he was enraged and terrifying. Write that he raised his voice loudly enough that the neighbor across the street came out onto her porch, that his face was red, that he slammed the car door twice, that our daughter started crying and put her hands over her ears. You see what's happening there? In the second version, the judge reaches the conclusion, and a conclusion a judge reaches independently is far more powerful than one that you suggest. You have also just given your lawyer 3 things to go find for you: a neighbor with a name, a child's reaction, and a timeline. All 3 completely usable in helping a client set up their testimony in court. 2 rules about honesty in a narrative, and these are not optional. Quotation marks go around quotes only. If you are paraphrasing, make sure you note that you're paraphrasing. Don't use quotes. And if you do not remember something, write that you do not remember. If you don't remember the color of the t-shirt, say, I don't remember what t-shirt. If you don't remember what kind of car, say you don't remember what kind of car. It was blue, 4 doors. I don't remember what kind. Do not fill gaps with probably happened. Use things that actually happened. Don't use what she always says. What did she actually say? Or paraphrase what she actually said. A narrative with invented certainty will be taken apart by the opposing counsel. And once one line in your narrative fails, the whole thing is gonna go. Your credibility on everything else that you're testifying on in your case is then called into question. Write your narrative the same day, not that weekend, not next week, not next month, and not 3 years later. Memory does not improve, and a narrative written 3 months later reads exactly like what it is. Too late. One more thing that pairs with this pretty well. After a verbal exchange, a short, factual, unemotional message to the other parent, sort of referencing what happened, can be very valuable. Not a bait, not an accusation, not a speech. A confirmation or confirming email. Here's an example. This morning at pickup, you told me you were keeping her through Tuesday. Please confirm. That kind of a message does 2 things. It puts a time stamp on a conversation that otherwise left no trace, and gives the other parent the chance to confirm it or deny it in writing. Either way, any type of response helps you, and just sending it helps you. Because if your narrative about that interaction, that verbal interaction with the other parent actually took place on June 17th, and you write a narrative about June 17th and what happened in addition to keeping her through Thursday, that is a way to credibly support your narrative. So confirming emails are always a good thing. No conclusions there either. So stay away from conclusions and just state facts. So finally, you just need to be honest with yourself about what a narrative is and what it is not. Your own notes usually do not go into evidence for their truth. Typically, your own notes are excluded from being requested in discovery because they are prepared by you in anticipation of litigation in the future. So it is usually considered a protected writing. So they don't go into evidence. But what they do is they let you take the witness stand 2, 3, 5 years later and testify with dates and details instead of saying it happened all the time. And they show your lawyer where the real corroboration is located. The neighbor, the pediatrician, the school, the receipt. This is not a small thing. In a case that starts at 50-50, being the parent who testifies with precision while the other parent testifies in broad generalities and conclusions, it's often the entire difference. So here's where I ask you to actually do something. I'm known to be direct as well as transparent. So I'm going to be direct because being gentle about this has not worked. Frustration is not evidence. Being right is not evidence. If the only thing you bring me is how strongly you feel, I cannot convert that into a parenting plan or into your testimony, and neither can any other lawyer. So here's what you need to do. Starting today, whether or not you have a case, keep your log and your narratives. Keep them in one place. Date them. Written on the day that it happens. If you need to record it with a voice-to-text note, you can send yourself an email with that recording or with the transcription of it. This doesn't have to be hard. It just needs to be complete, and it needs to be timely. Use neutral language if you can. No adjectives about the other parent. No diagnosing. No editorials. Just facts. A log full of insults is worse than no log at all because it makes you look like the source of the conflict. Move your co-parenting communication into writing at any time you can and keep it civil enough that you would be comfortable having a judge read it and read all of it because judges very often do. If your emails are entered as evidence, the judge will read them. So you can enter them as evidence, but so can the other side. Assume every time you send a text or you send an email that you're sending an exhibit to a future case. Collect third-party records as you go, not later. Pediatrician records, school attendance, tardy records, letters from the school, notes from the teacher, daycare sign-in sheets, therapist billing receipts. These all carry weight. You didn't create them, but you're collecting them. So they lend credibility to your narratives and to your log. Write down who saw what. Not to drag your family into court, but because a neighbor, a coach, a teacher who witnessed something and can say so out loud is worth more than 100 pages of your own recollection. And do it even when nothing is wrong. The parent who only documents during a crisis has a record that looks a bit like a manufactured story. The parent who documents routinely has a record that looks like the truth. You cannot build this backwards. That has got to be the hardest conversation I have with people in my work. And it happens when someone comes to me 2 weeks before mediation or even 6 months before mediation. They're already separated and they're trying to reconstruct facts that happened 3 years ago, even 6 months ago. It's a real problem. And if there's nothing to prove it, how do you use it? So the mechanics of mediation, some people don't know how this works, most mediations today happen by video, whether it's public mediation or private mediation. Even in person, you and the other party are almost always in separate rooms. And by video, you're in separate virtual rooms. The mediator moves back and forth. You may never see or speak to the other party at all. Very common. I was in mediation this week, and I did not see the other attorney, and I did not see the other party at all. The mediator is not a judge. The mediator does not rule, does not decide who's credible, and will not tell you that you would win. Here is what surprises clients most. I am not making legal arguments in mediation. There is nobody to argue to. Argument is for a hearing or a trial. Mediation is a negotiation. So all of the documents and the texts and everything else that exist, those are not things that are going to support your position. If your position is that you want to have 80% of time sharing and sole parental authority, and your documentation supports that, then that is a strong position to go into mediation with. Chances are, if you're working with me, I have already had a conversation with the other attorney and have filled them in on some of the things that exist, some of the facts. We can very often tell when a case is going to settle at mediation or if it is not, because if the parties are way far apart, and the facts are actually in hand, and both attorneys have the facts from their client in hand, you can pretty well tell what's going to come out of it. Okay, so you want to judge the whole plan, not the calendar. A parenting plan that you come up with in mediation is far more than an overnight count. It allocates decision making, whether one parent has final say after conferring or if they just have sole parental. It sets holidays and summer. It can govern travel, including whether a child leaves the country without the other parent's written consent. It handles exchanges, communication between households, right of first refusal, relocations, how future disputes might be resolved. I have watched parents secure meaningful protections in a plan and still leave convinced that they lost because they were measuring one number, or they were measuring against a standard that doesn't comport with what the law provides. Read the whole document before you decide how you did in mediation. And we probably need a different video on preparing for mediation, but today that's not the topic. So before you make a judgment as to whether or not you feel like you got screwed or the other side got all that she wanted, take a look at the overall process. And then I implore you to also look at the amount of money that you saved by not going to trial. So, on the topic of money, the field is not level. The parent with less money feels pressure the other parent does not. When you cannot fund a trial, the law starts at 50-50. And if your record is thin, you are negotiating from a corner and you know it. That is real. I'm not pretending that it's otherwise. Two honest things about it. Walking out of mediation does not relieve that pressure. It usually raises it. Because the trial you cannot afford today in mediation does not get cheaper 6 months from now. And the single most effective way to improve your position without spending money on trial is everything I just described in this video, which costs you nothing but a little bit of time and consistency. Mediation is the point in your case where you get to decide instead of a stranger in a black robe deciding for you. I promise you, a judge will never issue an order that either one of you will be happy with. You can build something around your actual child, your actual work schedule, and your actual family in ways no statute contemplates, and no judge has the time to learn about your family when you're in mediation. After mediation goes and you start moving to trial, a judge is going to apply a presumption to a record, and the record is whatever you created and brought to the table. So bring something. Start tonight. Bye, y'all.